Okay, so you have there your warrantless search. You have to remember that under the Bill of Rights, a person or a home cannot be searched as without a warrant, without a search warrant. However, there are certain exceptions to that rule, meaning you can search a house, you can search a person, you can search any building or a car warrantless as long as it falls under the exceptions. And these exceptions are the following. When the right is voluntarily waived. So a very clear example for this one is when you pass by checkpoints and then the military or the police officer asks you, pababa sa imuhang window. So in that manner, by asking you to lower down your what do you call this, kanang screen, you are voluntarily waiving your right to privacy. So meaning, makakita ang police officer sa sulod sa imuhang sakyanan. And if he sees something which is of contraband or illegal within the plain view, then he may search your vehicle accordingly. Now, when the right is voluntarily waived, is further explained in the first paragraph. For the valid waiver of a constitutional right, it must appear first that the right exists. Meaning dapat, you have the right to voluntarily waive your right to be searched. Now, this right is only available to individuals 18 and above. Second, that the person involved had knowledge, meaning you are aware of your right. And lastly, that the said person had an actual intention to relinquish that right, meaning you as a person who is being asked to lower your screen, you are aware that you are about to relinquish your right from privacy. So the consent must be voluntary, unequivocal, specific, and intelligently given, uncontaminated by any duress or coercion. So, mauna siya. A search will be done to you if you voluntarily waive your right to it. Meaning, ma'am, okay lang ma'am, kapkapan ka na mo, or sir, okay lang kapkapan ka na mo, moingon kag, yes. So, you are, in that manner, you are waiving your right to privacy. So, mo na, makapkapan na ka. Ana. So, that is a valid warrantless search. So, an example for that is in People versus Umawing. So,
Sir, question, sir.
okay, question.
Sir, so pwede di na sir kanang inana sir kanang moingon ang ano kanang police nga. Ma'am, ay kanang for example sir moingon ang security guard sa mga ma'am, pwede ti kakapkapan niya. Masulod ka sa mall. Ana sir, pwede di ka mo wave ay pwede di ka mo dili ana sir kanang kapkapan ka na. Nakay search warrant. Pwede di na sir.
Good question, Miss Pericano. Remember, the Bill of Rights, these rights are only available against agents of the state. Question, is a security guard an agent of the state?
No, sir.
No, di ba? So, you cannot say no to a security guard because he is a private security being hired by the company or by the mall. Nakuha?
Yes, sir.
Okay, so that's why the Bill of Rights will not work against private individuals. Your Bill of Rights will only work against public entities, against public officers, against agents of the state. Klaro ta? Klaro ha?
Klaro, sir.
All right, so an example here is in People versus Umaweng. The accused driving a vehicle was stopped at a checkpoint. So, gihurong siya sa checkpoint. Kunya, pag-inspect sa vehicle, ang mga soldier nag-ask ng permission sa driver. Kung unsa bay sulod anang bag ni mo na kana nasa ilalom sa spare tire. So, ang akusado pod, iyang gibuhat, gipakita niya tong bag. And then, nakita man dito sa bag ang marijuana. So, pwede nila ito i-search and i-seize because you have given your right na ipakita tong bag, nakitaan pa yun nila in plain view, then pwede nila gamiton as evidence laban sa imuha. So that's why be careful when you waive your rights. Sa karon, estudyante pa man mo, you are still considered private citizens. So learn when to exercise, when to waive your rights, and when not to waive your rights. And at least sa karon pa lang, kabalo na mo na ang Bill of Rights di ay will only work against agents of the state, against public officers, against anyone who is of public nature, kami kita. So, it will not work against security guards, kay private lang man sila. Another example of that is, for example, kabalo mo anang mga JNT, kanang mga parcel delivery, mga ingana, di ba?
Yes,
You're aware of that. So, there was this one case wherein letter A person tried to i-package ang marijuana sa bag. So, gideliver niya sa isa let's say, sa JNT. Ihatag niya sa JNT. Ano ang JNT? Abrihan na ko kay gusto na ko tanawon kung nabay kontraband dire. Kunya ni ana tong tao na no, gi-raise niya iyang right as to privacy and right niya na not to be searched. So mo to nag-ingon ang Supreme Court na kaning mga JNT, kaning mga DHL, kaning mga naga-deliver og parcels, they are private individuals. Hence, dili mag-work ang Bill of Rights against sa ilaha because they are private citizens and not agents of the state. Klaro?
Yes, sir.
Alright, sige. Okay, kanina sa pa, searches of passengers at airports. Nga naman, airports manggod kay dili manggod, this is for public safety. Hence, when public safety is concerned, you as a private citizen, your rights will be limited. Because iway man nimo kung unsa ang better right. Your right to privacy or right to public safety. Asa man na mas bugat, it's public safety, di ba? So mao na madelimit gyud imong rights pag naa ka sa mga airport, naa ka sa mga ship or any public service na area, or for example kanang sa mga terminal kana. Now, in People versus Gatward, it was held that when the accused checked in his luggage as a passenger of a plane, he agreed to the inspection of his luggage in accordance with custom laws and regulations, and thus waived any objection to a warrantless search. Meaning, katong pasahero sa eroplano, so kay tungod nisugot siya musakay anang eroplanohan na, then dapat unsa may luggage niya, unsa may gamit niya, dapat ma-subject to search. Kay public safety man atong ginatanaw diri. So, public safety is heavier compared to your right to privacy. Nakuha, guys?
Yes, sir.
Alright. So in Aniag versus Comelec, the Supreme Court said that in the face of 14 armed policemen conducting the operation, driver Arellano, being alone and the mere employee of the petitioner, could not have marshaled the strength and the courage to protest against the extensive search conducted on the vehicle. Consent given under intimidating or coercive circumstances is not consent within the purview of the constitutional guarantee. Unsa may pasabot ani nakasuhan ni. Si Arellano is a driver of a vehicle. Now, katong gipangutan na siya na, sir, okay lang ba abrihan ni imuhang ilalom sa imuhang sakyanan? Wa siya mabuhat. Actually, wag siya katingog. Because there were 14 police armed. Hindi lang policemen, armed policemen. Meaning, kada isa silahan ay bit-bit na sandata. So, ang giingon sa Supreme Court, ang iyahang, wala man siya giingon, di ba, na whether to open it or not. Ang iyahang silence, ang silence si Arellano should not be construed as consent. Dapat dili na to siya i-interpret as consent. Ngano? Kaya na-intimidate siya sa 14 ka policemen. armed pag yun. So that is not consent. As a matter of fact, you are intimidating the driver here. Hence, there is no consent in the search of his vehicle because he was intimidated. Naklaro ang story ni Anyag versus Comelec?
Yes, sir.
Alright. Mangutana mo ha kung if na may mga questions or mga saba ka ng... Okay. Next is the stop and frisk or known as the Terry search. Dili itong Terry ha na kinida number 1, number 2, katong ana good. So when you say stop and frisk, i-stop nimo siya, kunya i-kap-kap nimo iyang body for pieces of evidence. Mo na ginatawag na stop and frisk, and sa other jurisdictions like for example sa United States, it's called as the Terry search. As a matter of fact, the Terry search siya, not siege. Terry search is being asked multiple times in the bar, and sometimes daghan po policemen nakabalo aning Terry search. Kay tungod nga ang ilang lecturers kay mga lawyers. So ang mga lawyers pwede nag-impart sa theory or sa doctrine of the Terry search or the stop and frisk. So what is the Terry search or the stop and frisk? In Manili versus Court of Appeals, the Supreme Court said that the validity of the search is akin to stop and frisk, defined as the vernacular designation of the right of a police officer to stop a citizen on the street, interrogate him, and pat him for weapons whenever he observes unusual conduct which leads him to conclude that criminal activity may be afoot. In this case, the policeman chanced upon the accused who had reddish eyes, walking in a swaying manner, and who appeared to be on drugs, thus the search. So in Manalili versus Court of Appeals, what happened here was that kaning mga policeman naka-observe og isa ka tao na pula kay iyang mata, unya naga-sway-sway in a manner. So tanaw nila reddish eyes, naga-sway-sway, high yun ni siya. So mo to gilapitan nila, they introduced themselves as policemen and said, "We will conduct a search because you appear to have committed a crime." So mo to pagpat nila, nakit-an ang droga. So mo to, according to the Supreme Court, the search upon this person who was very high is validated because he appears to have just committed a crime and he was properly arrested. Since he was properly arrested without a warrant, pwede nimo ma-apply ang stop and frisk. Meaning pwede ka mag-kap-kap sa iya for any other pieces of evidence sa iyahang gibuhat na conduct na krimen. Now, what are the requisites for there to be a valid stop and frisk or Terry search? So, this has been answered in People versus Sichua. According to the Supreme Court, for a stop and frisk situation, the police officer should properly introduce himself and make initial inquiries, approach, and restrain a person who manifests unusual and suspicious conduct in order to check the latter's outer clothing for possibly concealed weapons. So you have to remember that when you are about to search a person without a warrant, you have to introduce yourself as police officers, and you should tell him that you appear to be suspicious. So that's why we are going to perform this stop and frisk and Terry search on you, because we are police officers and we just want to check whether or not you have just committed a crime or not. So here, the apprehending police officer must have a genuine reason in accordance with the police officer's experience and the surrounding conditions to warrant the belief that the person to be held has weapons or any contraband concealed about him. So this will, when you become police officers, experience will teach you when and how to catch a person who you think is suspicious looking and perhaps he who's just committed a crime. So please don't be frustrated when on your first assignment, dili mo kabalo mag-identify which one is suspicious, because only experience can teach you when and how to be good at deciphering whether or not a person is indeed has committed a crime. Okay.
Excuse me, sir.
Okay.
Sir, ang uban ako mga classmate wala kasulod kay brown out.
Okay.
Diri sa mo sa poblasyon of over. Char.
Sige, I understand. Sige lang kayo naka-record man to, di ba? Tama ba? Oh, naka-record.
Yes, sir,
naka-record ta. So, i-upload lang yapon ako ni. Ha? Tell your classmates. Okay, so you have also to remember here that a search and seizure should precede the arrest for the principal to apply. Kasi pasabot ani. You have to arrest this person before you can apply the stop and frisk or the Terry search. Meaning, you have to, with a warrant or without a warrant, you have to arrest him first before ka maka-apply og stop and frisk. So, sir, you look suspicious. You appear to have been just committed a crime. I am a police officer, so you arrest him. So you restrain his movements. So I am police officer, blah, blah, blah. And I am going to conduct a stop and frisk, a Terry search on you. So, pak. Yeah. So, nakita na mo yung contraband, then that will be admissible as evidence against him. Klaro ta sa stop and frisk or the Terry search? Kasi wag mo kung materi-teri. So remember si Terry, ha? Okay. Where the search and seizure is an incident to a lawful arrest. Again, mo na siya. A person lawfully arrested may be searched for dangerous weapons or anything which may be used as proof of the commission of offense without a search warrant. So here in People versus Stelia, the Supreme Court said that the prevailing rule is that the arresting officer may take from the arrested individual any money or property found upon the latter's person, that which was used in the commission of a crime or was the fruit of the crime, or which may provide the person arrested with means of committing violence or escaping, which may be used in evidence in a trial case. The search must, however, be contemporaneous to the arrest and made within the permissible area of search. Hence, ang pasabot sa People versus Stelia, before ka maka-search, dapat mauna gyud ang lawful arrest. So, i-arrest sa gyud siya, meaning i-restrain sa iyang movement before ka makahimo og search upon his person or upon his permissible area. Muna lang pasabot anang People versus Estelia. Questions?
No, sir.
Wala. Search of vessels and aircraft. Again, warrantless na siya because public safety demands it. And sometimes, may explain sa Roldan versus Aria. So a fishing vessel found to be violating fishery laws may be seized without a warrant on two grounds. First, because they are usually equipped with powerful motors that enable them to elude pursuit. And secondly, because the seizure would be an incident to a lawful arrest. Okay, so ingon sa Supreme Court in Roldan versus Aria, pwede ka mag-warrantless search sa isa ka fishing vessel o sa isa ka boat na nag-violate og fishery laws if nag-present ni siya. If kay tungod, paspas magud ning mga motor aning mga fishing vessel, so paspas sila makahawa, so wala na kay time maka-arrest sila, ha. So second, you have to immediately arrest them para maka-perform kag search over them. Now, in Hizon versus Court of Appeals, the court upheld the warrantless search of a fishing boat made by the police on the strength of a report submitted by the task force Bantay Dagat. So, when you become police officers, be wary of tips or informations made through or coursed through your hotline. Because chances are these are correct reports from your within your jurisdiction. So kaning Hizon versus Court of Appeals gialaw ang warrantless search because time is of the essence. When you say time is of the essence, you don't need to secure a warrant, a search warrant, because kaning fishing boat na ni may leave at any time and they are very paspas sila maka-elude ba for arrest. So, imong buhaton, dakpa lang yun sila para maka-search ka sa ilahang pump boat or sa ilahang boat and makuha nimo tong contraband or anything illegal out of it. Nakuha ba guys ang concept aning search of vessels and aircraft?
Yes, sir.
Ayun
Yes,
yung
sir.
Yes. Ito to na pangutana.
Wala, sir.
Wala.
Wala, sir.
Okay, sige. Search of moving vehicles kani. Very common labi na sa katong pandemic na to na time. A warrantless search of a moving vehicle is justified on the ground that it is not practicable to secure a warrant. Alangan. Diba, for example, ako, muagi ko sa Banaw na checkpoint. For example, si Mr. Sumambot, muagi po sa Banaw na checkpoint. Alangan naman, mangayo pag search warrant ang police diha kada agi namo, kada agi sa individual na tao, di ba? It's not practical. So that's why warrantless search is allowed when you search of moving vehicles, especially in mga checkpoints. So here the Supreme Court said that the warrantless search of a moving vehicle is justified because it is not practicable to secure a warrant. Because the vehicle can move quickly out of the locality or jurisdiction in which the warrant may be sought. So searches without a warrant or automobiles are also allowed for the purpose of preventing violations of smuggling or immigration laws, provided that sige. Oh, may problema. Sige. Searches are made at borders or constructive borders like checkpoints near the boundary lines of the state. So usually there are checkpoints in borders sa tuang mga areas because diri man gud mag-agi ang mga contraband. Like for example, there are a lot of reports that Boston and Katiil are being used as grounds to cultivate marijuana and gina-transfer downwards diri sa Baganga down to Katiil, down to Mati, then eventually to Davao City. So muna naay mga borders diha, nagi mga checkpoint diha. Now, one such form of search is a stop and search. So when you say stop and search, meaning is pa-stop imong vehicle and then mo search sila. So without a warrant at military or police checkpoints, which has been declared not to be illegal per se so long as it is required by the exigencies of public order and conducted in a way least intrusive to motorists. So that is the ruling in Valmonte versus Revilla. Now, you have to remember that your right to privacy is always under the right of public safety. Sorry. Di ba ako ulit? Okay, sige. October 29 at 8 o'clock in the morning. Okay. Thank you, ma'am. Sorry. Okay, sige. Ako na muna saan. Ayos. Okay. Sige. Sige. Sige, ma'am. Anyway. So, wait lang. Asa ka stop? Hello? Sige ako last nag-iingon. Sige ako last nag-iingon. Can anyone remember? Sige, anyway, sige. In Valmonte versus Revilla, the Supreme Court here emphasized that your right to privacy is always inferior to the right to public safety and public order. Mo gina, every time the Supreme Court decides a case on search and seizure, i-weigh in nila kung unsang rights ang involved. Like for example, you as a person who has a right to privacy, is it superior or inferior to the right to public order or public safety? So, one ang court, why will I choose your right to privacy na ikaw rin isa katao over a lot of people who needs public order and public safety? So, definitely, mag-weigh in ka ng Supreme Court to the bigger right, which is the right to public safety and public order. Hence, i-allow ang warrantless searches during exigencies. When you say exigencies, during times of crisis, times of danger, for example, katong pandemic na time. Di ba, grabe kaya sa ato, grabe kaya ang checkpoints, kung pwede lang. I remember at the height of the pandemic, I passed by 15 to 20 checkpoints. May na lang akong ID kay, nagamit kita akong pagka-ID. So, may nang isuhan mi sa DOJ yung ID kay, kung dili, no, na, stuck me forever sa checkpoints. So anyway, that's one of the perks of being the top law enforcer in the region. So I encourage you to move the ladder so that you can have your own perks. Any questions so far?
And so far, sir.
Okay, so inspection of buildings and other premises for the enforcement of fire, sanitary, and building regulations. Now, for those of you who will join the Bureau of Fire, this is very applicable. You don't need to secure a search warrant because it is of primordial importance na dapat safe ang imuhang building against fire intrusion or any sanitary or any building regulation. So, basically, it is an exercise of the police power of the state and would not require a search warrant because these are routine inspections which, however, must be conducted during reasonable hours. Alam nga naman. So, alam naman mag-search kakaadlawon. Ano sa difference sa buntag? Di ba? Sa ambot lang kung i-search mo kung naibay kung sa diha, ghost or manananggal or black lady di sa imong building. Ambot imong fire marshal ka. So, you have to remember that when you conduct a search, you have to be reasonable po. Ay po ng kadlawon na pukawan mo ang owner na tara mag-conduct unsa search for fire safety and sanitary safety sa imong building at 2 a.m. in the morning ko ay pagkapunyeta. Anyway, moving on. Where prohibited articles are in plain view. Kani gid diri gid matigi ang mga tao, ang mga akusado. So, when you say plain view, kung say makitaan sa view sa imong mata sa police officer ha. So, mao nang plain view. So, ang plain view dili mag-apply if kanang example na drawer kunya na contraband sa sulod. Dili na siya mag-apply sa plain view kay na-cover man siya, naman siya sulod unless of course you are Superman or any superhero who has X-ray vision, then the plain view will apply to you. But since we are just normal beings, plain view lang kita kung sino makitaan sa tuang mata. So objects in the plain view of an officer who has the right to be in the position to have that view are subject to seizure and may be presented as evidence. The plain view doctrine is usually applied where the police officer is not searching for evidence against the accused, but nonetheless inadvertently comes upon an incriminating object. People versus Musa. So, ang ingon sa People versus Musa, ang police officer need not search. All he has to do is just in plain view, nakita niya inadvertently, na ay marijuana, pag-ask na ko sa imuhan, abrihan na ko imong window, nakita na ko sa imuhang left corner, klaro kayo sa akong mata, di na ako kailangan mo silip sa ilawom, ang marijuana dried leaves. So, that may be searched and seized and may be used against the accused. Muna pasabot sa People versus Musa. Again, the Supreme Court in the same case enumerated the elements of a valid seizure based on the plain view doctrine. So, A prior valid intrusion based on the warrantless arrest in which the police are legally present in the pursuit of their official duties. So meaning, this is very applicable in checkpoints or in areas which require public safety na kanang i-ask pa ka na pwede abrihan, ano ni, pwede ba abrihan mong bag ka na. And then, the evidence was inadvertently discovered by the police who have the right to be where they are. So, next, the evidence must be immediately apparent and the plain view justified the seizure of the evidence without any further search. You have to remember that an object which is subject to search and seizure under the plain view doctrine should be within the plain view. Meaning, dapat di na ka mo search pa, di na ka mo, di pa mo kinahanglan abrihan, di pa mo kinahanglan i-unravel kung saan may naka-cover, ana. Kanang magtanaw yun mo, that's it. Plain view. Contraband, ana. Klaro guys, ang plain view doctrine.
Yes, sir.
Okay. Search and seizure under exigent and emergency circumstances. So in People versus De Gracia, the raid of and the consequent seizure of firearms and ammunition in the Eurocar sales office at the height of December 1989 coup d'etat was held valid, considering that the exigent and emergency situation obtaining the military operatives had reasonable ground to believe that a crime was being committed, and they had no opportunity to apply for a search warrant from the courts because the latter were closed. Under such urgency and exigency, a search warrant would be validly dispensed with. Again, kaning People versus De Gracia, applicable lang ni if present ang facts sa case. Sa imuhang case na gina-undergo nimo, pasabot, you don't have to get a search warrant if emergency ang situation. Second, if sarado ang korte, kung saan man mo pangayog search warrant na sarado man ang korte, you can definitely exercise your right to warrantless arrest. Search, warrantless search. Naklaro, guys?
Yes, sir.
Yes, sir.
Okay. Kanini, itundo na ako ni sa inyo ha. The exclusionary rule. Evidence obtained in violation of Section 2, Article 3 shall be inadmissible for any purpose in any proceeding because it is the fruit of the poison tree or it is the fruit of the poisonous tree. Diba na-encounter na ninyo ang fruit of the poisonous tree?
Yes, sir.
Alright. So, always gina siya ginabalik-balik, fruit of the poisonous tree because we are, unsa manggod, kamo manggod ang evidence custodian. So, when we talk about evidence, ang evidence manggod could either admissible or inadmissible. So, mauna, be familiar with the concept of the fruit of the poisonous tree. Or ang, what do you call this? Ang bunga na nakakalasong punuan. Tama ba kung Tagalog, ano? Anyway, moving on. Okay. Karon, there has been a new issuance among within the jurisdiction or within the Philippines that when you execute a warrant of arrest or when you execute a search warrant or when there is a warrantless arrest, meaning tanang arrest o tanang search, there should be body-worn camera. So this is the new practice now among police officers. This has just been promulgated in August 2021 and naglibog yung mga police officers ani kay sige ni sila adto sa akong opisina, sir tabangin ni ating body-worn camera, sir, kay kami ang madamay. Yes, kami gid mo madamay, ano ko sila ha. Now, this is relatively new and I want to introduce this as early as now because sooner or later mahimo magid mong police officers. Some of you ha, kay ang uban magid makabalo ko mag BFP man siguro ang uban or mag BJMP, but at least kabalo mo ba sa procedure sa balaod ron. Now, tanang arrest or tanang search there has to be body-worn cameras or BWCs. That is Administrative Matter number 2106-08. So it says here, this administrative matter shall be called as the rules on the use of body-worn cameras or BWCs in the execution of warrants, may it be a search warrant or a warrant of arrest. Now, the scope of this administrative matter states that it shall apply to all applications, issuances, executions of arrest and search warrants under the revised rules on criminal procedure. See, nakabutang po din, these rules shall also apply to warrantless arrests. In short, tanan. Sa tanan-tanang arrest ninyo, kinahanglan ninyo mag-body-worn camera or BWC. Now, the reason why, i-interject na ko diri ang human rights. The reason why gi-promulgate ng body-worn cameras because remember during the time when President Rodrigo Duterte came in as President of the Philippines, di ba? His number one propaganda is the war on drugs. Kaning war on drugs man good, it brought upon chaos on the Philippines because daghan ang naglaban, daghan ang ni Alma sa iyahang way of capturing the accused or the respondents na ingon ng human rights, please, we have to do something because the police officers cannot explain as to why nangamatay ang mga akusado. So, in order for there to be clarity, ingon sa CHR, ingon ang Commission on Human Rights na Supreme Court, please exercise your powers on procedural making na kinahanglan na ay unsan ay accountability on the part of the police sa pag-execute og warrants of arrest, tanang arrest. So they have to wear body-worn cameras kay para ma-record nato og tarong kung kinsa ba gyud ang naglaban, ang police ba gyud ang naglaban o ang akusado ba ang naglaban. So mao ni siya, mo ning end result sa numerous complaints in the Commission on Human Rights kay daghan ng laban, daghan ang nangamatay, and daghan forced disappearances. So mao na kinahanglan na nato mag-use og body-worn cameras among the policemen. Nakuha ang concept of body-worn cameras?
Yes, sir.
All right.
Yes, sir.
Okay, sige. So, stop share sa ta. Nama mo question? Na may pangutana or wala?
Wala, sir.
Wala. Okay.
Wala, sir.
Sure. Sige, palayon ta sa alright. Palayon ta sa human rights na area. So kato, I interjected the warrantless arrest and the warrantless searches because na discuss mong good siya. So para one time big time na mapila ko siya discuss, thoroughly discuss na ko siya kay para masabtan ninyo and para namoy idea. And at least it will, on your part, it will help you ba na when can you arrest a person, when can you not be arrested, when can you be searched, or when can you not be a search. Kay sa karon, you are still private individuals and at least you have a better knowledge in the law ron ba. So dili na mo kanang singka-singkahan sa mga any person who has power. Anyway, continuing our discussion on Commission on Human Rights. So the CHR is an independent NHRI. So it's created under the 1987 Constitution, established on May 5, 1987. So the commission is mandated to conduct investigations on human rights violations against marginalized and vulnerable sectors of the society involving civil and political rights. civil, the right to life, mo na atong nag-exist ang body-worn cameras because ang ilahang civil right, which is the right to be alive, to be free from being incarcerated, na tamper magudto tungod anang drug war. So mo na through the initiative of the Commission on Human Rights and through the Supreme Court's procedural making powers, nagawas tong administrative matter on the use of body-worn cameras. So unsay basis nganong dapat na ICHR ta? So according to one author, it is created as a response to the atrocities committed during martial law. So again, maski ako, wa pa ko na panganak atong martial law, but based on history, di ba, there were a lot of forced disappearances, a lot of killings, a lot of human rights violations. So hence, namulat ang mata ng taong bayan, kaya ang mga proponents ng ating constitution, sila ay gumawa ng provision sa ilalim ng 1987 Constitution, which creates the CHR or the Commission on Human Rights. Plus, they also added a lot of additional provisions pertaining to human rights, such as Article 13 on social justice and human rights. So here, it defined the creation of the commission. Also, Section 1, the Congress shall give the highest priority to the enactment of measures that protect and enhance the right of all people to human dignity, reduce social, economic, and political inequalities, and remove cultural inequities by equitably diffusing wealth and political power for the common good. And lastly, you have here Section 11, Article 11, the state value, Article 2, the state values the dignity of every human person and guarantees full respect for human rights. So, mao ni imo mga basis or mga provisions nganong naatay CHR. So, kani, human rights. So, under Section 17, there's hereby created an independent office called the Commission on Human Rights. So, kaning commission shall be composed by chairman, blah, blah, blah. Nagana siya composition. Okay. Appeal po sa annual budgeting ang Commission on Human Rights. Actually, di ba namatay ginatawag na GAA or the General Appropriations Act. Kanang GAA, diha ginabutang ang budget sa tanang agencies of the government. So that includes my department, the Department of Justice, that includes your department, the DILG, kung pila ang kinahanglan ninyo na budget per year. Apil po diha ang appropriation sa Commission on Human Rights. So GAA, General Appropriations Act. So Section 18 states here the Commission on Human Rights shall have the following powers and functions. For a sec, I think this has been extensively where they okay, my bad. Okay, so powers of the and functions of the CHR: investigate on its own or complaint by any party all forms of human rights violations involving civil and political rights. So it is the body which receives complaints whenever there are violations of human rights. Now, it adopt its operational guidelines and rules of procedure and cite for contempt for violations thereof in accordance with the rules of court. So the CHR has its own court or has its own judiciary for as long as it involves violations of human rights. Provide appropriate legal measures for the protection of human rights. So not only is it capable of investigating, litigating, but it also provides legal measures, gives victims remedies when it comes to human rights violations. So it also has the power, visitorial powers over jails, prisons, or detention facilities because it is the right of the accused to be allowed entry of his attorney or his lawyer or any relative. Establish a continuing program of research, education, and information to enhance respect for the primacy of human rights. Again, there is a need to continually study the subject of human rights because human rights tend to expand now and then. If before, gamay lang atong human rights, karon nagadaghan siya because we are trying to open new opportunities to certain marginalized sectors. Recommend to Congress effective measures to promote human rights and to provide for compensation to victims of violations of human rights or their families. Okay, so the CHR recommends to Congress or to the Legislative Department, we're gonna ask them, hey, can you create laws so that human rights may be protected? Monitor the Philippine government's compliance with the international treaty obligations on human rights. So the CHR serves as the tig check whether or not, hey, kaning Pilipinas ba nag-observe ba ni sa atong conventions sa iyang treaties, kung follow ba ni siya sa mga what is laid down as standards for human rights. So mo na ang trabaho sa CHR. Daghang siya trabaho yun. Grant immunity from prosecution to any person whose testimony or whose possession of documents or other evidence is necessary or convenient to determine the truth in any investigation conducted by it or under its authority. So, the CHR may, not appoint, may determine a certain person to be immune from prosecution. Muna yung mga star witness nila, immune from prosecution because naa sila ikaingon as against this certain powerful being. Request the assistance of any department, bureau, office, or agency in the performance of its functions. So again, it can summon help from any departments available to it, appoint its officers and employees in accordance with law, and perform such other duties and functions as may be provided by law. So this is your composition of CHR. So please do not memorize this. Okay? It will not definitely come out in your exam. I'm just trying to tell you unsa ang unod sino yan sila ng iyan sang CHR. So you have there the commission and bank, isang director, blah blah blah, etc. etc. So you see, they are a well-organized department. Alam nga, funded man po sila at the same time sa international conventions, not only by our GAA, they are also supported by the international community. Basta human rights, ganit, daghang kwarta niya. Joke lang. Basta hindi mo pala kwarta man si Sir Ray. Alright. About the commission. So, yeah. Again, balik na. Any questions so far?
No, sir.
Wala. Okay, so umanan eh. The reason why there is a CHR is because of the martial law. So okay, so may vision sa CHR. So it tries to envision a just and humane Philippine society of persons equal in opportunity, living a life of dignity, and forever vigilant against abuses and oppression. And its mission is to be the conscience of the government and the people. So it seeks to truth in human rights issues and prevent incidents of human rights violations. So as beacon of truth, we make people aware of their rights and guide government and society towards actions that respect the rights of all, particularly those who cannot defend themselves, the disadvantaged, marginalized, and vulnerable. Kanig yun ang inaprotektahan sa mga NHRIs or sa tuang, in our case, sa CHR, kaning mga disadvantaged, marginalized, and vulnerable. Alam nga naman, Mupanig ang CHR sa mga rich, powerful, di ba? Hindi man sila ang nagka-problema, but ang nagka-problema yung kaning mga disadvantaged, marginalized, and vulnerable. Labi na ang poor. Muna, pait yung kayo basta mapobre. That's why I always encourage students to get out of poverty by doing good in your academics, because your academics is your one way out, is one of the many steps on your way out to poverty. Actually, one judge taught me, although harsh ang iyang gitudlo sa kuha, ana siya sa kuha na dapat manggod ang I don't know if you agree with me, ha? Dapat manggod ang increase sa population nato are those who are educated, those who knows how the right thing should be done, mga ingana, instead of those who have less in life. Why? Kaya kung sila daw ang propagate, kung say iambag nila sa community, murag niana siya ba? So napaisip ko. But then again, I'm the type of person who is not into commitment of relationships and not into marriage life. So anak ko na, sige lang judge kay murag dugay-dugay para siya na storya na to. Anyway, icebreaker lang to. Moving on. Mantra sa CHR. So, dignity for all. Dignidad. So, this is your commission and bank. When you say and bank, tanang commissioners present. Tanang higher ups sa CHR are present. Sorry. Unfortunately, Commissioner Gascon died just recently. So he was the fifth commission of the CHR. Right ba siya? So you have your other commissioners such as Commissioner Gomez Dumpit, Commissioner Pimentel Gana, Commissioner Tanodra Armamento, and Commissioner Eugenio T. Cadiz. So most of the all of them are lawyers. So that ends part of your lecture. So I hope you learned a lot, or at least lang man learned by heart what needs to be learned